Hello, this is Matt on the Moon Lambo channel. A 13th amicus brief has been filed in the SEC v. Ripple case, although technically it's an application to file the amicus brief, but in filing the application to submit the amicus brief, the actual amicus brief is included as an exhibit, so it's effectively filed anyway. It's just, is the judge going to accept it or reject it? And I have to tell you right now, so a couple interesting things. This was filed by an attorney within the XRP community named Fred Rispoli, and I've highlighted a number of things from him over, well, much of this year. He actually sued, and I think this was in April, he sued Bill Hinman and Jay Clayton, and ended up pulling that lawsuit back just for now, though I do believe that's going to be coming back at some point. But he ended up speaking with Attorney Deaton, and he just kind of pulled back on that one. But I do think that one's still coming, so you may be aware of Attorney Rispoli for that reason. It is pretty cool, though, to see an XRP community member attorney filing an amicus brief, and they did it on behalf of another firm. And I have to tell you this. This is buck wild. Like, what? I kid you not. You'll see why. What this firm is doing, I've never heard of such a use case. I had no idea that the XRP ledger, and thus XRP, was being used for such a thing that I'm going to cover in this latest Moon Lambo Hot Jam. It is interesting as hell. In fact, we got this tweet. I'll just share this with you now at the outset of the video here. This is from David Schwartz, who of course is Ripple CTO and co-creator of the XRP ledger. And I think this amicus brief is probably what prompted this tweet. And David Schwartz said, "There has to be a more efficient way for me to learn about all the cool things people are doing with XRP Ledger than reading amicus briefs." And fair enough, because I'll tell you, I had no idea. It's like, you know me, I'm Mr. XRP, right? I'm pro XRP. This is an XRP-centric YouTube channel. It's my favorite crypto. It's my ride or die, as the cool kids would say, right? But I didn't know about all sorts of utility that XRP had until these amicus briefs were filed. You can think about tap jets. And we got specifics from IRemit, and fine, we understood on-demand liquidity before that, but still, there was that. The details of spin the bits, how that works. And now we've got one from a firm called Reaper Financial. Yes, you heard that right, Reaper Financial. But before digging into this bad boy, which I did print up and I highlighted all the most interesting bits from my perspective, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice. And you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. Now, Attorney Hogan had the following to say about this amicus brief. Our very own Fred Rispoli has filed an amicus brief on behalf of Reaper Financial. The brief is strong and to the point, highlighting another use case of the XRP ledger. The library case showed us how vital this is, and pointing out the absurdity of the token as a security argument. Yeah, exactly. Now, I will tell you this, and fine, I'm biased, but this is powerful. This is truly powerful, and arguments were made that I've not seen argued in this way before. So Attorney Rispoli did a fantastic job, and this is Attorney Rispoli right here. And again, I think many of you are familiar. If you follow my channel, I highlight stuff that his perspective fairly regularly. I mean, there's like four that I highlight regularly. So it'd be Attorney Deaton, Attorney Hogan, Attorney Bill Morgan, and Attorney Fred Rispoli. Those would be the several that I tend to go to because they're just most vocal, and I really appreciate the fact that they're always articulating their perspective on Twitter. And so let's just go ahead and jump into this thing. And I'm telling you guys, I've never seen anything quite like this. This is the coolest freaking thing. So check this out. Interests of Amicus Curiae. So that would be Reaper Financial. And this is, again, written by what I'm covering here. And I highlighted the most interesting parts, and I'm going to try and remember to scroll through as we cover this because I know some of you like to look at the screens as we're going through this. This was written by Fred Rispoli. Reaper Financial LLC's use of the XRP ledger has not been addressed by the parties or by current and proposed amici. As explained further below, Reaper Financial utilizes its own digital currency unit, RPR, that is, 1, overlaid upon the XRP ledger, 2, has a use case entirely separate from Ripple Labs or Amici, and that is a project based on a token voting to eliminate the circulating supply of other tokens, including XRP itself, and 3, uses XRP in fractional amounts in connection with the transactional cost for using the XRP ledger. A finding by the court that the XRP ledger and XRP are inherently securities would severely impair Reaper Financial's ability, as well as other similarly situated projects, to survive. Although Reaper Financial's interests overlap with those of other entities granted amici status by the court, its use case of the XRP ledger and XRP are at the same time novel and distinct, such that its interests are not adequately addressed by defendants or amici. So I'll pause and note here, that is absolutely true. Having read this whole thing, no other amicus brief went into depth about, I mean, you could argue maybe spin the bits because there's a representation of Bitcoin, but this goes into greater detail because there's this RPR coin, and there isn't any other amicus brief that goes into what the consequences of negative finding on XRP and the XRP ledger, like what that would do to other coins, tokens that were created specifically on the XRP ledger. Because understand, this RPR coin, it lives on the XRP ledger, and it requires XRP in order to exist. Anyway, the amicus brief continues. Reaper Financial is greatly concerned with the SEC's apparent years-long position that, in addition to XRP, the software code that comprises the XRP ledger is itself a security/investment contract. The SEC's argument, taken to its logical conclusion, goes even further than XRP token holders that merely buy, sell, or trade XRP. It would negatively affect companies such as Reaper Financial that tangentially use XRP via transaction costs when utilizing the XRP ledger. In other words, by simply using the XRP ledger as a mechanism to transfer value of any type, Reaper Financial, according to the SEC's litigation theory in this case, is by definition engaging in the sale of unregistered securities. But such an argument would necessarily render other electronic ledgers, such as Microsoft Excel or Google Sheets, securities per se, as these users similarly rely on these programs' software code to properly use their spreadsheet functionality. This overly broad, all-encompassing standard sought by the SEC should not be allowed. So I was pausing now. That is an excellent argument. I've never thought about it that way. That is powerful. I am so glad that Fred came up with that. I'm assuming he's the one that came up with that anyway, because he wrote this. Think about it. When you state it like that, just the idea, because it's a perfectly reasonable comparison. Because if this represents some sort of investment contract or security per se, how is Microsoft Excel legal? Why isn't the SEC going after Microsoft for the usage of Excel as an electronic ledger? Because it is used for that, right? It's so obvious the SEC is off. And that's why, I'm so thankful for all of these amicus briefs. And I'm telling you, Fred did a fantastic job on this. You're going to enjoy this. Like when I said this is buck wild at the outset of this video, I ain't kidding. Check out what they're doing here as we go through this. Relevant factual background. Yes, this is where we start to get into some of the details of how this operation works. Because again, it's an operation designed to eliminate, aka burn, the coins so that they're just gone forever. Reaper Financial's, I'm at this point right here. Reaper Financial's primary mission is to act as a reaper of assets by purchasing and subsequently destroying them. And so, the first time I read that sentence, I couldn't help but laugh. And I'm not laughing at the project. I'm not saying it's a bad or stupid idea. It's just so out there and wild. I was just like, I love that people are doing stuff. I am for this all day or a day, okay? But I just, upon reading this, I've never heard of such a thing. You created a company to destroy cryptocurrency. You gotta love this stuff, right? I love that people are doing all these creative things. And it's just, this may not be well known to this point, but still it's getting some sort of traction. It's been around for almost a year at this point. I just didn't know about it. This is the coolest damn thing. So check this out. Reaper Financial's, again, I'm going to read that again. Reaper Financial's primary mission is to act as a reaper of assets by purchasing and subsequently destroying them. Gotta add that in. The company began its mission by focusing on reaping excess and undervalued digital assets issued on various blockchain ledgers. The goal is to prevent violent market swings by removing the excess and unvalued assets. Digital assets are targeted for destruction through a decentralized voting mechanism that occurs on the XRP ledger. The future goal of Reaper Financial is to allow reaping for any type of asset through decentralized voting, be it an auto loan, student loan, or mortgage. Think about that. So you could have your mortgage eliminated. That doesn't sound too bad, actually. Reap the hell out of that, right? Reaper Financial achieves its mission through RPR, its native digital token. RPR is a fungible digital token created by Reaper Financial on the XRP ledger, meaning RPR requires the use of the XRP ledger to function. Reaper Financial has no professional relationship with Ripple Labs nor its employees. Ripple Labs did not market the XRP ledger or use of XRP to Reaper Financial, nor did any marketing efforts of Ripple Labs or its employees play any role in Reaper Financial selecting the XRP ledger for the company's decentralized voting mechanism. Reaper Financial utilized the XRP ledger because, as compared to other blockchain mechanisms, the XRP ledger is more decentralized in nature, has the lowest transaction fees, and has the fastest transaction speed. So it's possible. No, who would have thought that instant settlement with finality, practically free transactions, virtually no energy usage whatsoever? Who would have thought that that would be appealing to people and result in them building neat things on top of the XRP ledger? Who would have thought that, right? And at this point, too, like XRP, although not literally the first mover in the space, obviously, it's among the first. Been around close to a decade at this point. And there's a real community, and there are real developers. And if you're building something on top of the XRP ledger as a result, it might be more likely that you're going to get attention and traction. So that's an additional thing that I just kind of think in a general sense. It's kind of outside the scope of what I want to talk about in this video, but I just thought I'd mention it. There are reasons that people choose to build things on the XRP ledger, obviously. And we'll see what sticks. I don't pretend to know. There are so many cool ideas and so many neat things being built on the XRP ledger that I didn't know about until recently. And I wish all of them the best. I wish all of them success. Some stuff's going to fail. Some stuff's going to continue to find success. But all of this is helping to ensure a thriving, healthy XRP ecosystem. And as I've said many times before, all you need is one use case widely adopted for a cryptocurrency to ensure long-term viability of that cryptocurrency. And XRP's sure got more than one. That's abundantly clear at this point, is it not? Anyway, the AMICUS brief continues. Reaper Financial achieves its business objective of reaping assets through RPR, where owners of RPR vote on which asset each owner chooses to eliminate through each holder's RPR voting share. The value of RPR is used to purchase and destroy the assets which were voted for destruction. These votes are called reapings and occur bi-weekly. With respect to digital assets, RPR owners that choose to vote in reapings choose which asset they seek to destroy, aka burn, thereby permanently destroying those tokens. The assets to be burned are purchased at market value so that holders of that asset class are not harmed by reapings. To date, Reaper Financial has purchased and permanently destroyed through reapings over 500,000 XRP worth of other XRPL, ERC20, and Zenfin tokens throughout 23 reapings to date. 500,000 XRP worth of that. This is the most wild, cool freaking thing. I'm here for it, man. Like it makes me wonder what other stuff is being done on the XRP ledger that I have no idea, and most people just have no idea about. So cool, and so again, that's why I think David Schwartz tweeted that tweet out. I mean, it seems pretty clear. Anyway, AMICUS brief continues. As the RPR ecosystem develops, reapings will also begin burning XRP itself. Reaper Financial does not require Ripple Labs or any other blockchain product's permission to purchase and destroy these digital tokens. RPR was created on the XRP ledger and is not a separate blockchain. The functionality of RPR is matched to that of XRP in speed, transaction fees, and validation to decentralized XRP validators. RPR would not function without the XRP ledger's decentralized network. RPR was created on the XRP ledger by use of another third-party application called SUM for a fee of 100 XRP, and that's XUMM. Oh yeah, I need to scroll down, don't I? Sorry, folks, for those of you looking at the screen. Hey, I remembered it now, though. There we go. So, yeah, here we go. So it's that SUM, XUMM, which of course was created by XRPL Labs founder Wietse Wind and his team. Anyway, Amicus brief continues. This fee is then burnt by sending XRP to a Blackhold wallet address. A Blackhold wallet is a digital wallet where assets may be sent but cannot be withdrawn, hence burning them. In return, the RPR token is issued to an XRP wallet address in the self-custodial SUM wallet. The creation of the wallets and RPR both require the forfeiture or burning of XRP as a mechanism of their utility. Every time an RPR holder votes to burn/destroy another digital currency unit or debtor account, the RPR network, because it is hosted on the XRP ledger, must utilize minute fractions of XRP for each vote. These votes are recorded and read from memoranda posted to the XRP ledger. For example, when RPR holders vote in a reaping, they must sign a transaction to vote, which typically costs 0.000012 XRP. The reaping of October 22nd, 2022 consisted of approximately 30,000 transactions, thereby utilizing approximately 0.36 XRP. Think about that. 30,000 transactions, just 0.36 XRP. Pretty cool stuff. Now, of course, it's designed to prevent spamming of the network. So, in an event where there's a tremendous attack, it just, it becomes that much more costly. It's the fees scale. So it works. So it's practically free, but you kind of get the gist. Even if you were able to temporarily slow down the XRP ledger, what have you achieved? You can't do it forever, and then when you stop, it just goes back to normal anyway. Anyway, now let's jump in right here. No party has yet substantively addressed the legal implications of the SEC's argument in the context of other non-XRP tokens issued on the XRP ledger, like AMICUS, iRemit, TapJets, and Spin the Bits. Reaper Financial has no common enterprise with Ripple Labs or its employees. Although these 5 companies do utilize the XRP ledger along with countless other network users, there is no case law supporting the allegation this common usage transforms the XRP ledger into an investment contract any more than Microsoft Excel or Google Sheets are transformed into investment contracts solely because these software programs share millions of users. With respect to cryptocurrency tokens, although case law is minimal, there has not been a case to hold the digital asset tokens per se are securities. Exactly. I really love that argument, the Microsoft Excel and Google Sheets, because when you think about it like that, it's so obvious. The SEC is so full of it. Oh, and I like here, too, Attorney Rispoli did cite the SEC library case, which was a win for the SEC, but check this out. Here's what he wrote. See also SEC library, November 7th, 2022. Granting summary judgment to SEC on whether defendant offered, and highlighted offered, LBC as a security, and not deciding whether digital currency token itself, LBC, was a security per se. Exactly. The judge did, let's just say, in addition to having a number of logical fallacies in his judgment, also decided to stay away from the more difficult aspects of the case. And he could have, but he did not state anything specifically as to the asset. LBC itself was a security per se, just by the nature of it existing. And of course it's not, but the judge didn't want to touch it. Well, I think that I think Judge Torres is going to be touching that concept here, especially with the fact that there are over 75,000 participants, represented by Attorney Deaton. There are now 13 amicus briefs filed. She seems interested in addressing this, actually, which is good. That's definitely very good. Now let's jump down to here, bottom of page 6. Currently, the transactional cost to vote in a reaping is roughly equivalent to 0.000, how many zeros is that? 0.000055344 dollars, valuing 1 XRP at 46 cents. The approximately 30,000 transactions that occurred during the reaping on October 22nd, 2022 cost a combined total of 0.36 XRP, which would be equivalent to 0.1656 dollars, so that's basically 16 cents, with 1 XRP valued at 46 cents. And check this out, and I just love this. It paints a picture of just how ridiculous the SEC's position is. Check this out. In practical terms, the SEC would apparently seek to require Reaper Financial and similarly situated projects that build on the XRP ledger with digital units other than XRP to abide by the securities reporting requirements for tens of thousands of transactions that, in the above example, burn XRP at a cumulative US dollar cost of less than 2 US dimes. This simply is not the purpose of the Exchange Act, was not remotely contemplated by the Exchange Act or its blue sky predecessors, and is not even feasible given the number of daily transactions on the XRP ledger and their pseudonymity. Exactly, which is why the SEC gets their way. They'd rather just burn it all down. We don't need to have a cryptocurrency asset class in the United States. If the SEC had their way, that's effectively what would happen here. The AMICUS brief continues. Additionally, it does not appear that any party's briefing has addressed the concept that not only is XRP itself burned as a transaction cost in each transaction on the XRP ledger, but also that parties entirely unconnected to Ripple Labs can unilaterally destroy XRP as an inherent right to being an XRP owner. One of the many unique aspects of blockchain technology, such as the XRP ledger, is that the software permits the creation of black hole wallets from which XRP can never be recovered once sent. In the context of traditional securities, such as shares of a company, Ripple Labs could, pursuant to securities reporting requirements, buy back its shares from the marketplace and absorb them, reducing the number of outstanding shares, commonly called a share buyback. But no investor in Ripple Labs may do the same. At best, a retail investor could maintain shares in Ripple Labs and could hold those shares until death, but even then, such shares would pass to owners' heirs by intestacy or escheat to the state. In contrast, Ripple Labs has no control or ability to prevent Reaper Financial from reducing the circulating supply of XRP by destroying it. The closest, and I love this, check this out, the closest analog would be to owners of the US dollar burning those dollars. And even the SEC likely will not argue that setting fire to US dollars somehow constitutes securities transactions. And so yes, while it may be true that lighting money on fire is actually illegal, it doesn't mean that it's a securities violation. And even the SEC likely wouldn't argue that, although I don't put anything past them at this point. But think about that. That's the closest comparison that there is on such a concept. Would burning a United States dollar, although admittedly illegal, would that be a securities violation? Hell no. That's the closest comparison you get, though. Attorney Rispoli is correct. Isn't that cool? It's just wild what people come up with. It really, truly is. I have too much fun following this stuff. This is the coolest thing. I hope you guys got a kick out of that as much as I did, just like the whole concept of that idea. But additionally, Attorney Rispoli did a fantastic job putting this together. I think it's powerful. It presents an important message, and it is sufficiently different than information that's already been provided to Judge Torres via the other amicus briefs. It's just add to the pile. It's just more concepts, more ideas. The judge needs to know. It all adds up. So this is fantastic stuff. All right, I'll go ahead and wrap up here, though. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.